It is now 8:30, and welcome to week four of Introduction to Criminal Law. And so tonight we're going to cover the materials that we have to go over, and then we're going to conclude with a lecture, which I'm going to do as much as I can in terms of covering chapters 7 and 8, the PowerPoints that I've sent you already, and we'll adjourn promptly at 10 o'clock, regardless of how far we've gotten. And I do encourage you, if you have any questions or issues or concerns, don't sit on them. Don't be anxious about them. Contact me. And I already told you, you can call me, you can email me. So I'm going to go to and show you what I'm talking about now. Okay, let's go. Okay, so let's go to let's go to take a look at. Here we go. Again, as I remind you, you can call me, text me, email me any hour of the day, except the 25th hour of the day. Student I was talking to the other day didn't quite understand that. All it simply means is very simply, if you can call me the 25th hour of the day, text me or email me. I want to know how you did it, considering the fact that there's only 24 hours in the day. So that means that any of the other 24 hours, you can do those things. So what does that mean? In short, 24/7 is just my little funny way of presenting it to you. Okay? And again, I remind you, very important, if you have some course problems, be sure to use some of these sources that are available, especially issues about your APA. And if you need tutoring, I told you what to do. Remind you that our lectures take place only on even weeks. Since this is an even week, then we have a lecture. So therefore you can recognize that from the schedule, and the next even week is week 6. Recognize how the quarter is moving fast, even before your eyes, that your week 6 lecture, when you complete that, you'll have just 2 more lectures to go, and pretty much halfway point of the course. So you want to be up to date on that. So for the last time, I am going to remind you about this job fair. That's this Wednesday, the 26th of July. And that if you're interested, you can register by going to this link here, and you can communicate with someone from Career Services who can assist you with that. Okay, and then again, some of you still seem to be struggling with APA. I provide you with the link to go to. Here is, if you click on it, and where you can learn about APA format. Do remember, APA requires 2 things primarily that are big. There are other things, but the big things that I'm looking for is references at the end of the paper and in-text citations. Those are some of the key things that we look at. There's some sample papers that you can go to here, and then there's a method of formatting that's also important. I've been kind of lax with that, but I'm going to be cracking down on that as well. Again, of course, the writing process. So now let's get right to week 4, crime against people and the property. So we're going to talk about initially crime against people, and then crime against property, and 7 and 8 of the text, and you also have PowerPoints for that. And then there's an activity, crimes against people and the property, that I want you also to take a look at. And then your discussion post, robbery, burglary, and theft. The initial post is due tonight at 11:59 p.m. Central Standard Time. And remember, I sent you a rubric. Make sure that you look at that rubric and make sure that you're satisfied. You guys, most of you have done a pretty good job, and I make the comments to let you know. And they're pretty standard. And the reason that they're standard is because I use the rubric, and I know the rubric by heart. I know what I'm looking for. And when I see it, I let you know if you've done it, if you haven't. I also let you know if you're late with your discussion assignments as well, that you'll lose points. So I spell that out pretty clear. So your reply post is due on Saturday by 11:59 p.m. Central Standard Time. Finally, your written assignment, rape shield laws, and the quiz. I do recommend, as I said to students before, please try to make sure that you complete the quiz at the end of the week. And the reason why I suggest that to you is you will have covered the material primarily. There are students who think that because it's called a quiz that it's not very important, but I do remind you of something that we discussed in the open house, and that is that there is no final or midterm exam in this course. And so your assignments are based upon your primarily writing, your written assignments, your projects, which, as you've discovered already, are separate projects, not built up on one major project. And you get 100 points for those in the weeks that we have those. We had one in week 3. We had one in week 1. Now it's going to be a break until you get to the last 4 weeks of the course that you're going to have those. And those are very, very, very important. And you also want to make sure that you run your papers through Grammarly. Some of you, but most of you have been doing pretty good, but some of you have been hit with the percentage being too high of the sources that you utilize. The key thing that we want you to be cognizant of is that your written assignments should reflect your understanding of the material for that particular week, and it's reflected in your writing by your expressing your positions, and that you utilize the material. But I'm looking at your critical thinking, which involves looking at how you break down the issues and apply them to the facts and to the issues that are in each assignment. Very, very, very important that you develop this habit, and it's actually about transferable skills. I talk about this a lot, and sometimes students say, well, you know, I said, let me tell you, you want to get to the stage where you're like me. And I say me because as a lawyer, I have been trained to do that from day one. I couldn't even survive in law school if I didn't. But the key thing that you need to be aware of is that in today's world, that's one of the key things that will cause you to help you to be successful in criminal justice or any other field. And then today, if you could, or this week, take time to complete the mid-quarter student survey. And then my motto, start strong and finish strong. Adversity is a springboard to success. I'm going to take some time, I think, after, we might go 10 minutes or 15 minutes after 10, so that I can tell you why adversity is a springboard to success is important, and why you will understand that you as students will know that I as a professor understand circumstances that you all are engaged in as you pursue your education, and that the fact that you're going to run into issues and problems along the way. However, there is a way to succeed, and we'll talk about that, and I'll give you an example by giving you my story. Okay. So I want to be transparent with all of my students so that you understand what my expectations are, and that my expectations are not beyond something that I haven't done. And you're as smart as me. Trust me, I know you can become very successful at what you do. You just have to apply yourself. This is a calendar, again, which students oftentimes ask me, well, when is something due? The first course of action is to go to your calendar. And the calendar gives you in short form. But if you bother to click on it, it gives you more details. It tells you what you're supposed to be reading. It tells you also what your initial post is about. It tells you what your reply post about and when it is due. Then again, your mid-quarter survey, your written assignment, and your quiz. And you'll notice. So just to peek, show you what I'm talking about. After your assignments are due Sunday, we're going to hit August. And you'll see, even going down August, your written assignments all the way through the whole month of August, till you get to the course project. Then this will be, I think it's week 8, and this is week 9, unless I'm wrong. So you see course project there. I think then you got week 10, no, that's 8, 7 and 8. No, that's 8, then it's 9, as I said. And, I'm messing up here. Week 8, 9, then this is 10. This is 10 right here. So that by the time you get into September, that's when late at the end of August, you're going to see a course project, and then the last 3, and then your last day on the 15th of September. The only reason I did that is just so you'll see that about the projects, you'll see what I'm talking about. Don't forsake any of your assignments, but make sure that you do a good job on your projects, okay? Satisfy all the requirements, APA, Grammarly, content of the material as well. So now let's take a look at our module. Let's first look at the assignments again. Being redundant, I will repeat again. Notice that this talks about what rape shield laws are all about. Now, if you read down, and a lot of people do, they'll read the facts, they'll read this, then they'll stop. But they won't see this part after point number 3. When completing, and I'm kind of highlighting it right now. Okay. It says when completing the assignment in a, not a 1-page, but a 2 to 3 page paper, which does not count the cover sheet and does not count the reference page. Answer the following questions. Be sure to research these items, such as in-camera hearing. I want to know what it is. Use sources and references. Again, I'll mention, once again, I mentioned it before, never use Wikipedia. You will lose points right away from me because of the fact that it's not a credible source. Most of us professors have made this clear to our students. Not understanding that in high school, students are learning about why Wikipedia is not a reliable source. It's a Word document. It could have some good information in it. Unfortunately, I could come and change that information, and the next person can then be misled about the information. So it's not credible. Most websites are not Word and can't be changed. They're PDF, or the matter is they're a series of screenshots, or whatever the information is. You can't change it unless you're an administrator there. But here with Wikipedia, you don't have to be an administrator. So then submit your assignment. by using the Word document, and then, make sure that you attach it to the drop-down box, and it tells you how to do that. You know how to do that already. Yeah. Discussion posts, again, and it says by midweek. However, check the course calendar for specific dates, and your course calendar gives you the specific dates, and it also gives you the times these assignments to do, and all the instructions information that you need to get them in, and you already know that. Remember, I said before, it's okay to respond to more than one, and I like a lot of content. I like a lot of information. You satisfy the requirements, but don't be afraid to go beyond. Get discussional, get conversational, informational in each and every post. Even your reply post, don't just say, oh, it's a good post. Explain why it's a good post, what you liked about it, and then respond sometimes even with your own remarks about it and your position. And then finally, you have the quiz. 10 minutes, it's timed. Once you start, it can't stop, and you'll be warned 2 minutes before it completes. Okay? So now let's go back and look at the lesson content of the chapter. Of course, it always gives the objectives. We're going to talk about that. Crimes against people, property, and we're going to discuss a little bit about what theft is and how it originated. Once again, this gives you reading assignments, and it tells all the stuff that I've already covered, so that's a reminder there, and one little spot as well. Notice that it always says research. Research is very important in your written assignments as well, okay? And research does not just entail using your textbook. And then you need to learn about these definitions of assault and battery. And we're going to talk about some of these tonight. Rape and sexual battery, what larceny is. Another word for larceny, very simply today, is theft. False pretenses, you'll learn a little bit. The difference, robbery and burglary and what they are, we're going to talk a little bit about that. And so, be aware of the fact that there's been some changes in the law about burglary from common law. Common law, burglary occurred in the home, so there was only residential burglary. Now burglary applies to any dwelling, and it has to occur at nighttime. So, excuse me, but now the nighttime requirement has been done away with. And it says burglary today can occur in someone's house, even their vehicle, their business, or vessel, any time of the day, okay? And then there are these little things here that you can always do, and these are nice. These are very helpful. Drag and click. You look at the definition. So I'm going to do just a couple. The unlawful use of force against one person against another that entails some injury or offensive touching. Use of force that entails some injury or offensive touching. There it is. Some people use it with assault, but that's not and we'll talk about that in a minute. The willful malicious destruction of any real or personal property belonging to another person. Malicious mischief. A lot of people don't get that one. The breaking and entering of a dwelling of another with the intent to commit a crime, but not limited to theft, assault, while someone is present. While someone is present. A lot of people want to do this one, but that's not it. It's this. It's home invasion. So the point of the matter is, this one right here is this one. The word for malicious burning. Oh, I'm sorry, burning. So as soon as you see burning, arson. But the one I was looking for, okay, here it is. Breaking and entering a structure, conveyance of another with the intent to commit a crime therein, whether it's occupied. Then we would get to burglary. So I'm not going to do the rest of these. And then, of course, I encourage you to do your mid-quarter survey. 10 questions. Should take you a brief period of time, and they're anonymous. Not even I know who's answering, but I do ask you to be fair in terms of your comments and information that you need to know. And I had a student that constantly, whoever it was, they would, this student did this, said that the grading took longer. It took about a week to get out. Well, that's pretty close to the time that grades are due. Be aware that when you complete your assignments on Sunday, that following Monday you start your new week. And when you start your new week, even though you have access to it technically on before that, but you really start to get to your assignments on that Monday. And so I start doing grading on Monday, Tuesday, Wednesday, Thursday, Friday, all the way up until so I can finish. And sometimes I go over the weekend. So this past weekend didn't affect this course, but one of my other classes took me until Monday because we had a power outage, and you guys know about those. So anyway, that's the requirements for the week, and so now I pretty much have close to a little about an hour or so because I like to make sure that we cover the materials. So now I am going to get right into talking about these chapters. As you discern offenses against persons, now you're going to learn as you go through the process of criminal law that offenses committed against individuals or persons are probably the most severe. And the reason why they're most severe is because of the fact that life is precious, and that's kind of the way we consider it. We do consider property secondarily, but the primary situation there is that you cannot find yourself in a situation where you pretty much walk away from offenses against persons. If you commit a crime against an individual, against people, you will suffer some severe penalties. Okay, let's talk about assaultive offenses. So what is assault? Assault. What is assault? Assault basically is placing a person in fear of being injured or touched in a manner that they don't want. Now, the assault comes most of the time before the battery. Now, here's an example of an assault. I raise my hand and there's a person there, and I'm going to hit them with my hand or even with something, which gets to aggravated assault. We'll talk about that. Or and so before you actually touch that person or hit them, you've committed assault. And each state has a different definition, but pretty much across the line you're going to find that. Assault goes along with battery. Right? You hear people say assault and battery. So assault is basically the prelude to committing battery. Now, you can commit battery without assault, such as catching a person unaware. But if they're aware and they are placed in fear of being injured, then that's when you get to the assault aspects of it. And assault can actually put a person in a state where they can actually die. For example, if you pull a weapon on someone and you don't pull the trigger, but you pull it on them, you've committed assault and probably and so as a result of that, that person could go into cardiac arrest, they can die, or other issues can happen to that individual. So assault and battery, though, at common law, this is before we had statutes, which now you should be recognizing the fact that all, and we talked about this earlier, in earlier weeks, that our criminal law is codified. In other words, there are statutes in the various jurisdictions, the states, and then the federal government. And all criminal law in the federal government is found in Chapter 18 of the United States Code. There's some is contained in Chapter 18. Today, simple assault and battery generally remains a misdemeanor. Assault and battery, however, based on a public officer, elevates to felonies. Why is it? The reason is very simple, and it makes sense, is that we don't want you to place public officers, people delivering the mail, or people that are UPS, FedEx, police officers, fire officers, probation officers, that are working for the public good and are involved in generally our first responders. Don't want you interfering with their jobs. Don't you putting them in apprehension of receiving assault or battery, and you can receive felonies for that. Again, what's the difference in a felony and a misdemeanor? Very simply, the sentence in a misdemeanor is less than a year and or a fine. The difference is then for a felony is a year or more, and you could have a fine as well. Aggravated assault and aggravated battery. Again, that's when you get to including not just an assault, as I told you, with a weapon, for example, or using a caustic substance such as lye or either hot water or something that creates further injury to an individual. Aggravated battery using like anything. Now, aggravated battery can be an individual that uses their hands in some instances, such as if you're maybe, for example, a professional boxer, if you are a self-defense expert and you are registered and you have all those things, then it's not just simple battery by hitting someone with your hand or kicking or those things. Then we elevate it to aggravated battery. I've already kind of described these all, so I'm not going to go over them anymore. So the difference between assault, just very briefly, again, I've covered it, doesn't require you have physical contact. So, but battery does require, and I said this is a prelude to this. Some examples of assault: shooting in the direction of a person, but you don't necessarily hit them; threatening someone. Aggravated factors is using a deadly weapon or something that might cause great bodily harm to an individual. That elevates it to aggravated assault. Battery, examples: hitting or pushing someone, offensive touching, using excessive force to break up a fight. Excessive force means it's force that is unnecessary. Let's say, for example, if two people are fighting and you take out a gun and you shoot the person, that might be considered excessive force if you use, and they're just using their hands. Intentionally tripping another person. This is for many people to be aware of, usually students in school. A lot of juvenile offenses have occurred where battery was involved with someone intentionally tripping another person. I had a person once say, well, okay, does that apply in sports? That's a very good question. It depends. If you create some injury to a person by intentionally tripping that person on a basketball court, you know what will happen. You'll be put out of the game. If you have something as well with football. You will be probably taken out of the game and fined, and then there could be some further ramifications and those kinds of things. Using excessive force in disciplining a child can also end up in battery. Great bodily harm. This one here is an example of a discussion that whether or not this woman was involved in great bodily harm. Her 4-year-old threw his breakfast at her because he was pitching a tantrum, and so his mom intends on giving him a spanking on his butt, but misses and hits his head. He falls over and hits on the floor. The doctor diagnosed a concussion. Did she cross the line? California is kind of a weird state in terms of how they apply it, but this, in my professional opinion, could be arguably presented that there was no intention, no willful infliction of cruel and inhumane. It was a error. It was a mistake, and but there are prosecutors who have taken those kind of instances and attempted to turn them into felonies. Prosecution and defenses. Simple battery, all the prosecution has to prove is the act and general intent. In other words, they did the act and generally the result of what takes place. Aggravated, not only do you have to prove that it happened, but specific intent. That it means that that person intended to use this to create the aggravated aspects of it, or to commit a felony. Defenses that are often used, the degree of force is argued that can be used, but there are levels which, as we already know, excessive force. Law enforcement is under severe attack right now. Teachers generally are at a stage now in most jurisdictions now where there's zero tolerance that teachers participate in corporal punishment. The defenses are usually unintentional, like the one I just told you a few minutes ago. Situation was reasonable what the person was doing, or they were acting in self-defense. Common defense that's used, and I, as a criminal defense lawyer, took advantage of utilized that many times. Mayhem, you won't run across a lot. Willfully injuring a person so that they are not able to fight, for example, in most states, like disfiguring a person, causing acid or pouring acid or hot water or something. And they just have to prove, as a prosecutor, general intent. Most crimes under mayhem are now, you don't hear that term. It falls under aggravated murder or attempted murder. Hazing. We didn't have that when I was younger, but you know what it is. You've heard so much about it before. It usually happens in some kind of fraternity, sorority, or athletic team, or some kind of group. It's crazy stuff that you have to go through some kind of initiation. But the key thing is that it results in intentional or reckless physical or mental harassment, abuse of a person, and that being part of initiation. As many colleges, universities, and high schools have come down heavy on individuals who commit hazing, and rightfully so. And then these are some examples of hazing. Okay, I'm going to skip over that. Stalking. Stalking, placing a person under surveillance, threatening that person with bodily harm, sexual assault, confinement, or restraint, or placing, last part here, or placing that person in reasonable fear of bodily harm, sexual assault, confinement, or restraint. In other words, that person can feel uncomfortable to a level that, or a degree that they feel as if you might actually hurt them. You might cause them injury. And so that's what we're talking about in terms of that. And so the law law applies this very seriously, and it has happened a lot of times with entertainers, athletes, public figures. It says here in 2006, an estimated 3.4 million persons 18 years or over were victims of stalking. And California was one of the first states to make stalking a crime, obviously, because that's the home of many Hollywood celebrities, entertainers, and people of that level. And then the federal statute, the Violence Against Women Act, was amended to include stalking. And you know what that's all about. That's primarily significant others, spouses, and people of that level dealing with domestic violence. During the 1990s, a number of defendants were attacked, argued that they had a First Amendment right to be where they were. Most courts, those days, that's not true, because again, remember what I said at the onset. We're talking about dealing with attacking a person, they're placing them in fear of possible injury. Now we have this because of technology. We have the computer. We have these things right here, cell phones. We've got Android pads. We've got iPads, because now we have texting, because we have emailing. We have FaceTime. We have, you name it, Facebook. Not as much with LinkedIn, because that's more of a business nature, but you know, those kinds of things. The key thing is that what you'll use is you'll use technology or online contact to place the person in fear for their safety. Our state here, Illinois, has criminalized cyber stalking as a felony, which I think is appropriate. And I tell you, one of the things that you're aware of is the fact that there are people who have taken cyber stalking to such a level that it has resulted in individuals who they never had any physical contact with, and they have taken their own lives or attempted to take their lives. And so it's considered very, very serious, because it can adversely affect quality of life in people. Some of the states have amended their statutes also to include cyber stalking as well. But we're in a technological society. We discuss this in our classes. In fact, yeah, you're online right now. And so as a result, those kinds of things happen. A person who, you know, Facebook, what you can do, you can block somebody. You know, you can unfriend them and those kind of things. But, you know, a person can get your number and they can text you. They can send you emails through your email address, and there's all kinds of things, you know, that are taking place now. So, rape and sexual assault. Forcible rape, excuse me, is what is basically a sexual intercourse, forcing against the will of that individual. Now, statutory rape is different. Statutory rape is what we call, it's a strict liability offense. Now, we've talked about strict liability offenses a couple of weeks ago, or last week. Strict liability offenses require that the prosecutor prove that the offense occurred. There is no defense, I did not know. There is no requirement of mens rea and criminal intent. Just committing the act. So here we are, we have statutory rape primarily to protect minors. You know, with minors today, boy, you can't tell. You can look at them and they look really, really, really mature. Well, guess what? That's like dangling a carrot in front of a rabbit with something laced in it. It's deadly. You can go to jail. You know, she lied to me, or he lied to me, or they lied to me, or they led me to believe. Too bad. It still doesn't matter. So it is a strict liability offense. It is constitutional, and regardless of the consent of that minor, various jurisdictions have different levels of statutory rape. okay? And it can go all the way up. Usually it can start as low as 14-year-olds all the way up to 17 years old. The Haley's rule, I'm not going to deal with that too much. A person can be charged as aiding or abetting someone to sexually assault or rape their spouse. But I'm not going to spend a lot of time with that because generally we don't have that. And I already talked about statutory rape, and ages range from 16 to 18. I've seen 14-year-olds as well. Voice and consent are not relevant. Women under age 16, 17, or 18 are unable to give consent. The same with men that way. This is in the age that we're in now. The purpose that was the intent, but now it goes also to young males as well. Strict liability. There is opposition to these laws because people say, well, times have changed. Depriving women in their late teens of decide if they want to be sexually active. You don't want to get engaged in that with a person if you're an adult, and doesn't matter. They can't make the decision under the law. The law operates as we call loco in parentis in the juvenile court, which means stands in as the parent to say no. And no means no. It's not a comma. It's a period. It's an exclamation mark. It's not a question mark. Okay. And then, as I said already, gender neutral criminalizes sex between spouses, forcing. Now, let me say this about that. Generally, that occurs in individuals when they are separated or something of that nature. But if they're living in the same home and those kind of things, generally that doesn't apply. Expanding the definition, if a person is using a foreign object that person is not going to welcome, even if they're married, they could find themselves in a situation where some prosecutors will go forth and bring those again. It gets into the domestic violence aspects of it. Now, keeping in mind again that now it being gender neutral, it protects males as well as females. And then with the fact that now we have the LBGT issue injected into our laws now, where you have civil marriages and you also have now marriages that take place between men and women and women, then these laws apply in those situations as well. And then it says some jurisdictions divide the offense into classifications and degrees, and it depends on the severity of the activity that that person was involved in. Enacting rape shield laws. Now, what is a rape shield law? In the past, what happened is that when a person was a victim of rape, their sexual history could be used against them. Their promiscuity could be used against them. There could be, so what it did was it created a problem for individuals who were victims of rape, because oftentimes what would happen is that the rape victim actually was not only messed with by the defendant themselves, but then also the defense attorneys, and even some instances the prosecution. So now what happened is statutes that protect the identity of a rape victim, for example, are involved, because we want to encourage people to come forth and report rapes. One of the things that you ought to be aware is a person who is raped generally holds it quiet for a number of reasons, because of the way society perceives the whole situation. Yeah, it's serious, but at the same time, of all the attention that can end up on the individual who's actually the victim. And so rape shield laws came about to try to change that. It's not just minors, but it's adults as well. So protecting the identity of the victim or present disclosure of your sexual history. There's what we call in-camera hearings. In-camera means very simply that it is a hearing that takes place or information that's disclosed in chambers with the necessary parties that are involved in the issues, and not the public itself and those kinds of things. So each jurisdiction has a different form of dealing with this, but it is intended, again, to help victims because it is embarrassing to go through those steps. And people oftentimes, and then also there are times when people refuse to report rape because the power of that person that commits the offense, like a teacher or a public official or something along those lines, a wealthy individual, those kinds of things. And so the rape shield laws, this is what I just talked about a few minutes ago. Okay, so I'm not going to go into that detail. Sodomy is very simply oral or anal sex between persons and an animal. It can be consensual. If it's consensual, it's not illegal. But if it's unconsensual, it's a crime and is actually charged. But consensual sodomy is not a crime, and the Supreme Court has held that states may not prohibit consensual sodomy between same-sex partners. Well, obviously, since we have now the right to marry that people can do now, and according to the law, of course, you know, it's up to individuals whether or not they do that, but the point of the matter is that the law has said you can do this. So think about that. That statement is out the window completely because there are spouses that live like that, and so as a result, it's a person having sex with another person of a different race. A different sex, and those kinds of things. Not race. I didn't mean that one. That's totally out. Okay. When I say out, I mean that's not illegal. People can marry and be with whoever they want to. Loving versus Virginia, 1967 case, which is made into a movie called Loving, which I saw briefly, and I'm going to watch the rest of it again soon because I know all about that case. Sex offender registration laws came about in 1994, pretty much under what we call Megan's Law, a young girl that was involved there. But then now it requires, upon release, there must be registration. Registration includes the address. Any information is publicly available. You can check with your local sheriff's department. There are places that you need to be aware of that will advertise or send you an email. I've gotten some of those that say to you, you can check the registration, but you pay a fee. You don't have to do that. It's free and it's available generally by your sheriff's office in the county that you're in, or it could be in the Attorney General's office in your jurisdiction. You can check with law enforcement in your community, and they'll tell you exactly where you can find that. But it is publicly available. And so the problem that exists with these is that sometimes they get a little carried away, such as a person having to register for public urination in the park. And I'm talking about a person who's flashing. I'm not talking about a person but a person who, for whatever reason, needs to go and relieve themselves, and they can't make it to the closest washroom, but they're trying to be in a private situation in a public place. And so there are instances where I've known of people who have had this Megan's Law applied to them in their jurisdiction. I think these are unfair, totally unfair. So then the debate is, it punishes people based on status. Well, here's the key. There is a propensity for many offenders who commit sexual acts to be repeat offenders, recidivists. And one of the reasons is because of the fact that they haven't been, the issue, that the problem the controlling their sexual desires has not been controlled, and so as a result, they find themselves in situations where they continuously commit the offenses. Situations such as dealing with minors particularly. We're all aware of those kinds of situations because they're reported in the media, and it's something that to be concerned about. I personally, we were looking for a house. Always check the community where I'm living in and see, you know, where the sex offenders are. And there's been situations when we've opted not to buy or rent in a certain area because of that issue there. So, but many buildings now and associations where their homes now have a requirement, and that if a person has committed those offenses, they won't rent, they won't even sell, because the association will protect the individuals in that community. This is an example of Smith versus Doe. Notice I said it protects the individual. Held that Alaska sex offender registration may be applied retrospectively to defendants who were convicted prior to the act. So this has a situation where two defendants had challenged the statute, saying that it was punitive in nature, and punitive statutes can't be applied retrospectively. But the court said not so, that sex offender registrations are not punitive, and that's for protection of the public. So we get to that particular point. Then we start talking about child molester laws and those kinds of things. Okay. Child abuse, actions that are physically, mentally, or emotionally endangering the welfare of a child. Of course, that law has been applied quite a bit to protect children in situations because children are neglected. It seems like more, but I think that now it's coming more to the surface now. It has been for years and years and years. It's not a new thing, but it says since the 80s it has increased. Well, I think that one of the reasons why that statement is made, which I don't totally agree with, is that there's been increased focus, change in the laws, more reporting. You got mandated reporting, those kind of things. Mandated reporters are individuals such as myself, a teacher, law enforcement, and many other professionals, ministers, that if they're aware of or observe or something happens in their presence, then it must be reported. So that's why one of the reasons why that has happened. But it says due to age and vulnerability of children, these crimes are considered as strict liability crimes, mostly misdemeanors. Statutes require medical professionals and social workers to report instances, and that goes with what I told you of the people that are also mandated reporters. Controversy emerges over the question of whether drug use constitutes child abuse. I can tell you this, that in our state at least, the Protective Service Agency, the Department of Children and Family Services, commonly referred to as DCFS, takes the position that if a mother has drugs in her system and she is pregnant, they will take that child away, place that child in foster, or either with another family member, and then if the parent does not take care of the issue, clean themselves up, then they will not get the child back. But I have seen instances of children who were born with drugs in their system because of the mother utilizing the drugs while she was pregnant, and it has resulted in some serious problems that were long-term for that child, and or has created a dangerous situation for that child as well. So yes, that would be considered as abuse. Spousal abuse, we get into, again, domestic violence, physical, emotional, or sexual abuse of one's husband or wife. Courts can issue what we call protective orders or orders of protection. You know, here's the thing that I explain to people, and I understand spousal abuse very well. I'll talk about it at the end, why I really understand it. And going through, it doesn't have to necessarily be a spouse. It could be a significant other. But the bottom line is that it's just domestic violence. So the Violent Crime and Law Enforcement Act of 1994 deals with crossing state lines for domestic violence. I'm kind of a victim of that through a family member who was my mother, and I'll talk about that in a little bit. Interstate domestic violence, that is going across state lines. In this case, this person was convicted of kidnapping and interstate violence for assaulting his wife and driving her across state lines from West Virginia to Kentucky before he finally brought her to an emergency room. That's when you get into crossing state lines very easily, that's when you get into the federal offenses. Abuse of the elderly, infliction of physical or mental harm, taking the funds of those individuals. Most of these are civil proceedings, but they have gone into criminal, such as here in our state, Illinois. It is a felony to intentionally or recklessly cause injury to a vulnerable elderly person because you're placed in the same situation as children where you're helpless and you lean and depend on those individuals. And this is a case here which, if you read it, Dale and Janice Semister's uncle was taken to the hospital. The staff noticed that he had not had food in a week. He was covered in urine and dried feces, and he laid in a fetal position. And it seems as if there was a pattern based upon that of abuse that had taken place. So they were convicted of elderly abuse. That's a criminal case. False imprisonment is the crime of unlawfully restraining a person. Not all states make false imprisonment a crime, and most states classify it as a misdemeanor. And some scenarios are, for example, unlawful arrest by a police officer, jail warden not properly, or prison warden releasing an inmate according to the law, the way they're supposed to be released by a court order or something, and then the prison warden fails to follow it. Shoplifting, person is detained without a reasonable basis. Overzealous male who won't allow their female or vice versa companion to leave the apartment without yielding to his or her sexual demands. Kidnapping is abduction, carrying away of a person against the will of that person. It's a serious felony. Simple kidnapping, and then there's kidnapping for ransom. Of course, you know the difference. Simple kidnapping is you take that person away for whatever personal reasons. Kidnapping is in asking for some money or something valuable in return for releasing them from the kidnap stage. Asportation is carrying away property of the individual. Federal Kidnapping Act, after the Lindbergh kidnapping of the baby involved there, came about because it involves crossing state lines. Hostage taking also fits into kidnapping as well. Some defenses is that no, they didn't move the person or the person gave consent. And usually in kidnapping cases, just because a person said it, yeah, you say it if someone's threatening you or someone that's dear to you, you'll agree to it. But it's not willful consent, and it's not even really consent. It's duress. That's what we call it. Child snatching. These generally are crimes that take place, as it says, with children between divorced or separated couples or paternity issues, where one parent takes a child and leaves the jurisdiction. You see, oftentimes, it's not some neighbor or somebody kidnapping in those kind of situations, child snatching. But anyway, this usually ends up being resolved in the courts under the Uniform Child Custody Jurisdiction and Enforcement Act. Then the Parental Kidnapping Prevention Act was involved with what I talked about a minute ago, designed to prevent jurisdictional conflict over custody matters. It reduces the incentive. You can go to another jurisdiction and you can still be arrested for that child. In other words, let's say, for example, you go through a divorce or either paternity and then the child is awarded to a parent with a non-custodial parent, violates the visitation, keeps them beyond that, or takes them away, conceals them, those kind of things. You get into child snatching. Civil rights offenses such as individuals, law enforcement, or anybody who operates under their office, and it prevents discrimination, violating the rights of individuals based on race, sex, religion, national origin, and those kinds of things. But it protects individuals from injurious conduct by government officials or public officials, conspiracy against the rights of those individuals. Is also a civil rights offense. Deprivation of rights under color of law. What that simply means is operating in your capacity. Let's say, for example, this one. The U.S. Supreme Court upheld a conviction of this judge for treating a woman to deny custody in order to extort sexual favors from her. That's operating under color of law. So that the judge is using his office or position to deprive this person of their constitutional right to be free from sexual assault. Hate crimes, unfortunately, these are on the rise, particularly in the gay and lesbian community. For many years, hate crimes involve race and ethnicity. Now it's more on sexual orientation. But those individuals will commit a crime that normally would not be considered as serious, but because it's a hate crime or elevated to a hate crime, the offense goes higher and the potential penalty. Hate Crime Prevention Act eliminated the requirement that the person be engaging in a federally protected activity. In most state courts, it enhances the criminal penalty when convicted of one of these crimes. And that's it for that. Okay, so now I'm going to quickly do property crimes. So now remember what I said, you're going to get into more crimes that involve individuals who are depriving individuals of property, damaging property, things of that nature. Before we're dealing with the individual, protecting that individual. Larceny, taking away the property, depriving them of the property, and it amounted to theft, pretty much. And that's what we use pretty much today. False pretenses, obtaining money or property through misrepresentation. You know about those kind of things. You have Ponzi schemes. You have things that don't exist, false real estate transactions, so many different things. Embezzlement, using a position of trust to transfer or convey the money of another. That is, you are the trustee or the guardian over the funds and you're using them for yourself and not benefiting the party that is intended to. And then all the prosecutor had to prove is that the person intended to commit or defraud the victim. Receiving stolen property also fits in that category as well. Theft offenses today, as I say, include larceny, theft of vehicles, touching, shoplifting, looting, carjacking, and extortion. And then I already told you that the situation occurs quite frequently in the federal law under Chapter 18, which takes it to the federal level. Crimes so kindred as to belong in one category: embezzlements, theft, receiving stolen goods, And then this section, 659, provides penalties for committing these offenses dealing with interstate commerce, crossing state lines. And then this is a little chart, and I'm not going to spend time going over that. It just shows how larceny, and then how it was common law, and then what we call it today. These are primarily the things that we use today. The modern approach to theft states now include tangible as well as intangible property. Intangible property are things like things that ideas or, you know, taking copyrights and things of that nature, patents and things of that nature. Newer statutes includes other crimes besides theft and impose penalties based on the amount and character of the stolen property. Grand theft is most serious. Petty theft is a serious misdemeanor. What it is, it depends on the value of the property and how it's taken. And so it depends on, every jurisdiction has different laws in terms of how it applies. Intent to deprive, the willful design to take goods or services from another without permission or authority. That's when we get into theft. That's what it is. That's exactly what it is. Taking somebody's stuff that doesn't belong to you or been given to you. Embezzlement, again, one of the best known is the Ponzi scheme by a guy named Bernard Madoff, who is now incarcerated and will be forever. He embezzled money from people in the 70s. People lost 18 billion, not million, and many middle-class persons, because they were relying on this guy. They believed he was a legitimate investment advisor, and he was really, Ponzi meant that what he was saying wasn't even true at all. He was putting their money into things that didn't exist. In 2009, he was convicted of 11 federal felonies and sentenced to 150 years in prison. So, pretty serious, because there were people who, as they said, they lost their life savings. Robbery is very simply the crime of taking money or property from a person against that person's will by means of force or intimidation. Now, under common law, robbery was aggravated form of larceny, with a form of taking by force or violence. Force or violence has to happen before or at the same time as taking of the person's property. It is an offense against the person, even though we're talking about against property, but it usually involves some assault or battery. In other words, that person is forced to give up the item by threat of bodily injury or death. That is robbery. That's robbery, okay? Theft does not require that. Under federal laws, there are bank robberies. It's a federal offense. You already know that. Prosecutors only have to prove that it was in general intent. Some states have codified the common law. Other states classify robbery according to degree, depending on the circumstances and situations that occurred during the robbery. The key thing is taking with force, okay, and those kind of things. That an unlawful gun is a dangerous weapon. And the display of a gun instills fear in the average citizen. As a consequence, it creates an immediate danger that a violent response will take place. And so this is a case that this person and a companion robbed the bank with an unloaded weapon. Well, it's still a dangerous weapon as far as the person knows. And they said, well, it was not. But it's not up to the person to determine whether or not it's, the weapon is something that appears to create the, satisfy the requirement of forcing that person to give up something. Let's go back. Carjacking, taking of a motor vehicle by someone, force. Unfortunately, we run across quite a bit of that taking place. And so, but to the point that it usually hits federal because individuals usually will take those vehicles across state lines. But a carjacking under Chapter 18 could involve serious injury to the individual or either attempted that could result in the death of the individual, and it's a general intent crime. The U.S. Supreme Court said that the federal carjacking law applies to defendants with the conditional intent of harming the driver, and that's the key thing. We get back to that point. The idea is, if you don't give up the car, I'm going to hurt you. Holloway was convicted of carjacking, and his companion had approached occupied vehicles and threatened to kill. Now, some people have said, what about if the person just leaves their keys in the car and they take it? Is that carjacking? That has been argued that it's carjacking, but in the literal interpretation of carjacking, it is not. That's considered as theft of the vehicle, and we talked about that earlier. But it depends on the jurisdiction. Okay, the difference between robbery, I already told you, taking it from the person, obtaining extortion by threat or force. That's extortion, or inducement of fear, also called blackmail. Property is taken by threat with consent. Property does not have to be taken from the victim's person or present, and it requires a specific intent. Property taken by threat or force without consent, that's when we get no robbery. Felonious taking property off of the person or in immediate presence, that's a general intent. Notice the key. In this instance, the fear is immediate, so it's general intent. Extortion, specific intent, is that by the threat of force. And here, taking off the property with the person imminently in fear, okay, or by threat or intimidation. Forgery, we already kind of know a little bit about that. Making a false written instrument, changing it, such as changing your grades on a college transcript, such as taking a check and instead of making it $10, you add another zero, make it 100. Anyway, the federal law, the prosecution must prove the intent to pass bad money, those kind of situations, such as counterfeiting, and those making imitations of coins and so forth for the purpose of leading a person to believe that it's legitimate currency. Here's an interesting one. And whenever I get to this, I always take time to go over it because it's a very interesting scenario and it makes sense. Because the first time I didn't get it. It says in 1983, a popular West German magazine, Stern made the shocking announcement that they had 62 handwritten diaries from Hitler. The content of the diaries challenged the historical views concerning Hitler's characters and presented him as more amiable than had been documented. Many who had known Hitler personally were shocked because they thought, they said, no, this dude is not as good as this. He's bad. So anyway, after a few weeks, it was discovered the diaries were forgeries. Now, you think about this, is that these were in a magazine. But after a few weeks, discovered it was forgeries, even though it was an expert that verified the authenticity of the documents. But here's the issue. The experts compared the diaries to original documents that were also forged by the same person. So once a document is forged and compares it to it, it depends on what you compare it to. If you compare it to the original documents that were originated without someone else having previously forged it, then you're going to be able to know the difference. But if you use a forgery and match it with a forgery, what's going to come out with? It's going to say, oh, it's authentic, because you're not aware of the forgery that takes place. Uttering, passing instruments such as a check with the intent to defraud, distinguishes the actual forgery or passing a forged instrument, knowingly delivering a check. That's what is involved. You know it is, and you're doing it, not that you didn't know. Worthless checks, bouncing checks, rubber checks, that's what we call them. Many states now have pacified what we call Worthless Checks Act, and then in many jurisdictions it's a misdemeanor, and the offender usually has to pay a fee, you know, an SF or whatever fee, and often the charge is already posted there. If your check bounces, what you end up having to pay. Not many people go to jail for those. Burglary. Okay, now, I already told you earlier about burglary, but this is what it is now. Breaking and entering a dwelling of another. It says someone is guilty of burglary regardless of lawful entry of the dwelling. For example, intentionally remaining in a department store with the intent to commit an offense after the store closes. I had a young man who had a novel idea that I ended up becoming his lawyer. He was in a Kmart, and he ended up going into the bathroom, and he ended up climbing into one of the stalls, closing it, stood up on the toilet, and when the store closed, they came in, checked, and then, you know, no one was in there, the lights were out and everything. And so he ended up, after they had done that all, and the store was completely closed, he changes into ninja clothes, all black and all of that, and he comes out and he announces that he's going to rob the store. And so anyway, he ended up getting, someone pushed the alarm, and so he heard the alarm, so he ended up trying to get away. The doors were locked, he couldn't get out. So what he did was he jumped through the window of the store, and when he jumped through the window of the store, he was knocked unconscious and on the ground, and that's how the police arrested him. And I'm smiling because I remember when I was representing him, it was just the craziest thing. He had seen it in a movie or something, and, you know, tried it. But anyway, he ended up, you know, having some mental problems, as it was determined, and he ended up being found not guilty. Not by reason of insanity, I should say. He was guilty, but we pled and worked a deal out for him to help him out. I don't know what happened to that young man after that. Burglary is different from home invasion. Offender is armed with a dangerous weapon and persons are present. That's home invasion. Now, let me say this. How do you commit burglary? For example, in our scenario that we have, in our discussion, reaching into the open window to grab something in the house is burglary because you have actually entered the dwelling of another. Even if you take an extension, and let's say, for example, I have this ink pen right here, this pen here, and I stick it into an open window, and I grab something with that and bring it out, I've committed burglary, even if, because it's an appendage or either part of your body, your arms, your hands, your feet, whatever partially goes in, that's committed as burglary, okay? Burglary tools, if the person intends to use tools for burglary, even a simple screwdriver or a knife, those kinds of things. Scissors. Arson, intentionally burning someone else's house, now extends to vehicles and structures. Prosecution must prove and the person intended to do that. It can be a misdemeanor or a felony. It's a felony, of course, if it involves endangering the lives of individuals. Of course, though, it's a felony also if you do it with intent to defraud your insurance company. Now, here's an example here. I'm going to go in a minute there. A serial arsonist, this guy, John Orr, operating under color of law is what we called it. He was a former choir captain, and actually he wasn't at that time. So, but he would have been considered, if he's doing this while he was a fire captain under color of law. But he was a former fire captain and arson investigator, and so he set a series of fires during the 80s and 90s in LA. They would always start around highways. Anyway, he was arrested after police matched a fingerprint on a time delay device, and he was sentenced to life imprisonment because he was using knowledge that he had gained in this and that he was endangering the lives of individuals by being a serial arsonist. Malicious mischief, vandalism, basically, graffiti. Even if your light or gas or utility is turned off and you turn it back on, that's considered as malicious mischief. Some we refer to it as theft. Defenses to property crimes is mistake of fact. You took the wrong jacket, for example. That happens. I had a situation where I grabbed somebody's jacket and I put it on. I thought it was mine. Then I reached in the pocket and it had something in it that I knew it wasn't mine, so I returned it. Of course, at the time that you do it, if you determine that you decide to keep it, then in that instance, then it's no longer a mistake of fact because you're now intentionally taking the wrong jacket. Mistake of law concerns ownership of property, like, for example, issues about whose title property belongs to and those kinds of things. You could argue lack of intent, an alibi that wasn't you, insanity doesn't go very far, duress, that's got to be gun at head duress, someone is actually forcing you to do it and you had no. Intoxication, if it's involuntary intoxication, you might have a defense. But if it's voluntary intoxication, that is that you took a drink and you were drunk and did it, it's not going to fly with you. So, and that's it for that. Now, as I said to you earlier, I wanted to go. Let's see. Let's go back now and let's talk about what I had said earlier. Now, I talked about adversity as a springboard to success. I talked about the different things that we deal with. So let me take a few minutes and talk about this. I am a professor in criminal justice because of the situation that I'm about to describe to you. When I was 7 years old, my dad was murdered in our house. It was a guy who lived in the house. He was a roomer, and it turns out that he and my mom were having an affair. My dad confronted him, and when he confronted him, a fight broke out in the house, and the fight ended up in a bedroom where I was 7 years old, and 5 of my younger sisters were in there. The man took out a knife and stabbed him in the forehead, and my father ultimately died. Well, the man did not go to jail for committing the offense under a legal technicality, and so he ended up staying in the house with us. He ended up sleeping with my mother openly then at that point. He, in fact, fathered 2 more children that were girls by my mother. He used to beat her on a regular basis, so I thus grew up in a home where I witnessed firsthand domestic violence. Every weekend, there was something that happened and the police had to come. The guy would end up being arrested, and then my mother would be the first one to get him out. And so she was warned, to get away from this guy, but she still considered him as the breadwinner because we were on public aid and he was the one who provided the source. He was a worker in the construction business. At any rate, finally it came to 1963, and we moved out of our house and moved into another house because the area in Chicago on the west side became pretty tough. So my mother moved us to Gary. At that time, she moved us to an area called Terrytown, which was a nice family community. We had other relatives that were living there who had previously lived near us, and so we ended up going out there. So it was my mother, myself, my sisters, and then this man. And so he continued, to live there with us. He gave her some problems, and then an aunt came and stayed with us for a little while, and the problem stopped. But then she left and went back home. She lived in Michigan. So anyway, what happened after that is that on Memorial Day of 1963, when I was 13 years old, he murdered my mother. Not in front of us, but he stabbed her multiple times around the house, around the corner from the house, and drove her body across state lines. Remember, I was talking about that earlier. Into Illinois, on the south side of Chicago, parked her body, got out, and he ended up letting her bleed to death. He turned himself in. So by the time I was, and I wasn't able to go to my mother's funeral. I couldn't handle it. So I did not go. I went to the wake, and someone had to stay with me. At any rate, another aunt, the aunt that lived with us for a while in Gary, who lived in Michigan, came back and took my 7 sisters and I. By the way, my baby sister at that time was just a little over a year old, and I was, still changing. I was changing her diapers, and I was taking care of the house. I was the man of the house. I took care of the house. I cleaned the house. I did what my mother asked me to do. So anyway, we ended up being brought back to Chicago after my mother was killed, and stayed with another aunt in the city, and then wasn't working out there very well. That aunt, she heard me talking about different things and asking questions. So finally we moved away when I was 14 years old, and my aunt from Michigan took all of us and put us in this house, that house built. And when I was living there in 1964 and I was 14, I found out that the man who had pled guilty was going to receive 10 years. 10 years. But under the law, 10 meant 5. And that for good behavior, he could end up potentially serving 4 or up to 3.5 years, which is ultimately what he ended up serving. So I was very troubled at that time. I asked questions, and then finally someone told me there's these people called lawyers who handle it. Well, when I hear stuff, I go out and I investigate it and to find out what is going on with it. So because of my inquisitive nature and wanting answers to my questions, finally someone said to me, lawyers deal with this. I went to school and asked the librarian for a book. I took a book home from the library at school, and it was about lawyers. It was a very basic book. I spent the night reading that book, and then the next day, anybody I met from that point on, I would introduce myself as Richard Wright, and I'm going to become a lawyer. Well, as it was, I ended up going through some pretty tough times. I had trouble with my aunt there, not her directly, but more her husband. He wanted me to take his name. I didn't want to take his name because I was the only one who could carry the name forth. So we had problems. So I ended up befriending a lady that I had heard on radio, and we became friends. And then many years later, she legally adopted me. But this was years later. This was even after law school. She finally went to court, and we made it legal, but she had been in my life. But here's my point. is that I had relatives, starting with the aunt that I stayed with at first, not the one from Michigan. The other one, she said, "You don't have what it takes." She says, "You can't do this. You're not going to be able to do it. You're not that smart," and so forth. Listen, guys, I did not ever tell this lady, she has passed on now, that I was going to show her. What I did do was I did invite her to my graduation when I graduated from Northwestern University School of Law. But of course, though, I'm jumping ahead, because what happened is that after, I went through high school, and I ended up, some friends of mine had a family member friend who worked in a big law firm. It was a corporate law firm, and she got me a job in their mail room. And, people knew I wanted to be a lawyer, but they laughed. They said, "Oh, you're carrying your lunches." Well, the next thing is that I wanted a family, so I got married right away, and right out of high school. About a year, I graduated in '69. I got married in March of '70, and then started school in '69, going to school at night, working 40 hours a week in the law firm. I did not have a car. I took public transportation. I didn't have laptop, computers, all of that. We had big books. I had 2 big carrying cases of books. And I would have to be at work at 8:30 in the morning, and then I'd get off at 4, and I had to be in class at 4:30 on the other side of the downtown Loop area of Chicago, and I did. And I did it. I did it, guys. I ended up doing well. Here comes my first child in 1971. She's now 46. And then the second one came, she's now 45 and 72. But I was still persisting in going to school. And then also at that time I had a battle on my hands. The Vietnam War was going on, and they were taking young men into the military, and I had to go through some steps to battle that. But then ultimately they refused to take me because I was the only surviving male, because I had 2 girls. I had nothing but sisters, and so they wouldn't take me. So I ended up getting what they call a student deferment. And so I continued in school. But there were times when things really got tough. So in that law firm, when I got there, I let the lawyers know right away that I was going to be a lawyer. And I would talk to them, communicate with them. They saw that I was genuine. So then I became a file clerk in that same law firm. And then I became a law librarian in that same file, in that place. Well, what I did when I became a law librarian, this was before they had systems of research. I used the books. I'd be the custodian of the books, shelving them away, changing the pages as the laws were updated through their subscriptions that they had. And I taught myself how to legal research. Well, they found out that I knew how to do that. And so what they did was they said, "We're going to move you into a position as a clerk." Now it's called paralegal. And I would do research. I would write memos. And I would even go to court. I'd go to real estate closings, residential as well as commercial real estate closings. I'd go to corporate meetings and things like that and just sit and listen. Along the way, while I was a messenger, let me digress a little bit, I took a package one day to a gentleman by the name of Ray Kroc. And they called him Mr. McDonald because he was the founder of McDonald's. They did a movie about him recently, and I came to know him and learned a lot of things about McDonald's. At any rate, the point of the matter is that, guys, I was in school full-time, on public transportation, having to feed a family. I should tell you this, that my first wife, she was also in school, studying to be a teacher as well. So at any rate, it took me 7 years, from '69 to '75, to graduate with my bachelor's degree. 7 years. Hear me. And there were times when I would take one course, but I refused to take time off. I didn't go in the summers, but I went during a regular year that students were in school. So my kids were in school and I was in school. And so I continued to stay on the dean's list and the honor roll. I had problems that happened. I ran into family situations, financial problems, you name them. I went through a whole lot of changes, but I had my mind determined that I was going to obtain my education. So despite all of that I went through, so then it came time to apply for law schools, and people told me I should apply to 3 law schools. I said, I'm not applying to 3 law schools. I took the LSAT, which is a law school test that you take to be considered as a law student, and I didn't do as well as I could have because there were some things I didn't totally understand, but I still did okay. Well, anyway, my point being is this, is that I kept moving forward. So when it came time for me to apply to law school, they sent me the application. I applied. The application was very thin. It was just, you know, like 6 pages. You fill it out and so forth. We didn't have computers and all that to fill it out then. But when I sent my package in, it was like, you know, real thick. It was like really thick and had to go in a box because I put in a lot of detailed information about me. I told the story of my life, what I went through. So the law school had like thousands of people fighting for seats. They were taking 250. I was one of the first ones that they admitted that year into Northwest University School of Law. And so I continued through law school, continued struggling. One of the first things that happened in law school was that my wife at that time, who was a teacher, she graduated that same year. And 75, I graduated from Roosevelt with my political science degree, minoring in business. The schools went on strike, and we ran out of money. I had to study by candlelight. I had to eat beans and stuff. It was not easy. So we sent our 2 girls over to their grandmother's house for a short period of time, but pretty much we went through that. And I made it. I made it through. And by the time when I graduated, then my 3rd daughter came along, 1978. The point of the matter is that, guys, I decided that I was going to get it, and I got that degree. The woman who told me I couldn't make it, she came to the graduation. She never owned up to me as her nephew until that time, but I made it. And once I made it, she wanted to be a part of my life. The lady who had become like a mother to me and then would ultimately become my mother legally a few years after I started practicing, she was there with me to encourage me. But I was the one who had the drive. I was the one who had the desire. I was the one that would not let anything stop me. Sure, I was slowed down, but it took me 10 years, guys, from high school to law school. Normally it's 7 years, but I was not going to be deterred. I wasn't going to be turned around because that was my goal. So what ended up happening is that I met a gentleman when I was in law school whose son was my classmate. He was a criminal defense lawyer, and he introduced me to people like Johnny Cochran. He introduced me to a number of people. But the bottom line was he encouraged me to become a criminal defense lawyer when there was probably a propensity for me to be a prosecutor. I didn't really think about it, but a lot of people looked at me and asked me that. And I said I did not end up doing that because the gentleman told me that you will learn more about the system as a defense attorney. And I wanted to call my own shot. So I left the big law firm. By the way, I ended up not only, so when I got into law school, I worked in the summers at the law firm, and then ultimately I went back as a lawyer, but I didn't like corporate law, so I left 2 years later and started my own business. But for a while I worked with some other guys, then my own business. But anyway, I was continuing to move forward in the business of being a defense lawyer. I defended murderers. I defended murderers. I could handle any kind of case, drug cases, robbery cases. The one case I could not do was rape cases. I did one of those where a young man wanted to get back with his wife, and his ex-girlfriend tried to argue rape, and I had a jury, not a jury, a bench trial in front of a female judge who acquitted him and found him not guilty. And then I couldn't take child abuse cases. Where there was a case once I had, and the people lied to me, and I saw they had put cigarette burns on this child. And I withdrew, gave them back all their money, and told them they needed to get another lawyer, and the judge released me from the case. But other than that, I've handled those cases. I had some double murder cases. I had some very serious homicides that involved. I was very good when it came to juries. I'm happy to say that all jury cases I had, I won. Now, that is not to say that I didn't have some jury cases where clients went to jail. In those instances, either my advice wasn't followed or the client decided to do something that I didn't recommend, and as a result, I ended up going down. But whenever I did what I did in front of the jurors, I did pretty well. So as a result of that, I did well. In the meantime, 91 and 93, I went to seminary because ministry became important to me. So I went to school for that. I didn't completely finish because I owe a paper, but I got everything I needed to know. So anyway, the bottom line is that I continued. I ended up with a divorce, then a second marriage, and in my second marriage, I had one more child. So I had 4 girls. And with that situation, I continued to still move forward. And I ran into adversity there in that situation. And I just kept moving forward. Didn't let things stop me. I ended up leaving law in about 2000 to pursue a career in ministry and run some businesses, and did pretty good with those. But ultimately, I would end up taking a job with a town that had a corrupt police department, and I became their village attorney, village prosecutor. I became an investigator later on, dealing with internal affairs. And then I was a part-time police officer. I got my police training. I was able to have a badge and carry a weapon. I did all of this. So the point of the matter is I worked with corrections officers, probation officers. I was part of an organization called Probation Challenge, where I worked with people to try to encourage them to turn away from crime and to obtain their GEDs, because I became a fan of education, recognizing that the more education that a person has, the less likely they will be a recidivist or repeat offender. At any rate, I did all of those things, and then ultimately in 2011, I came to Rasmussen College. They offered me a job as an adjunct professor to teach business law, which I quickly, it was residential at that time. I said, I'll do it, but then I let them know that criminal justice was my area. And since that time, I have worked in criminal justice. I attained, as an adjunct professor, a lot of, I took time. Even as a part-time adjunct professor, I still was active doing extra things. I'm not afraid of doing anything extra. And as a result of that, it has helped me, it has helped other students. I still do extra. Like right now, the lectures that I do, I'm only required to do 1 lecture a quarter, but I do 6 lectures. I used to do 11, but because of the fact that I didn't get real good attendance or no attendance, I still kept doing the lectures anyway and then providing archives. The point of the matter is that I am, so anyway, I ended up becoming for a while, I was full-time as I am now, what they called State Program Coordinator of the School of Justice Studies. In other words, I was the person who was over the state of Illinois program for Rasmussen College, responsible for 4 campuses, our Rockford campus, our Aurora campus, our Mokina, Tinley Park campus, and then our Romeoville campus. And I used to travel to them, and I would interact with the staff, with the administration, and with students at all those places. And then when he changed that, then I started teaching more classes. I went from teaching residentially to teaching an online mode. You got to remember, I'm 67 years old. So I learned something totally that was before my time, how to use the computers and all of that stuff, and I'm very proficient at it now. The fact of the matter is what I am doing is just telling you that I am one who believes in success regardless of the obstacles. That is why you see at the end of your announcements the statement that I am now putting up to show you at the end of my weekly announcement. Here it is. Adversity is the springboard to success. And that is why I constantly remind my students, don't let anything stop you. Sure, you're going to run into problems. But I wanted you to know this so that you'll understand why I'm so adamant about your assignments. I want you to be good. I want you to be well-trained. I want you to be professional. I want you to be ethical in all your responsibilities that you perform in criminal justice, and that's the role. So anyway, I just wanted to share that with you so you can learn that about me. And that's why I'm so committed to student interaction. So with that, I'm going to say good night, and hope to see you guys in 2 weeks at week 6 lecture.